Okay, so just for recordal purposes, for the recording, just to reiterate again that the first renewal fee is due 3 years from the filing date, bearing in mind that the filing date differs for complete patent and for an international national phase patent, and then annually thereafter. Section 46.2 does provide for a 6-month grace period upon request to the registrar to allow for that extension to pay the late renewal fee. But then if we look at regulation 48 of the patent regulations, it stipulates that where grant occurs more than 3 years from the application date, the first renewal fee due, or any renewal fee in that instance that was due before grant, must be paid at grant. Otherwise, the patent will lapse. So if you have a look again at the timeline in front of us, you have your application date. 3 years from there, this application is still pending. The renewal fee would have been due at this date over here. However, grant occurred after the 3-year period, and it is then necessary that that renewal fee must be paid upon grant. Okay, so any renewal fee that was due during the pendency of the application needs to be paid upon grant. Otherwise, the application will lapse. Then there is a specific provision in terms of Regulation 67I of the patent regulations that is only applicable to national phase patent applications. So for convention application, this is not applicable. It only applies to national phase patent applications. And it provides for 2 scenarios. The first being that if grant occurs 33 months before the international filing date, or from the international filing date, then the renewal fees are due as per usual. Okay, so then Regulation 48 shall apply. So if grant occurs before the expiry of 33 months from the international filing date, then the renewal fees on that application, on that granted patent at that point, are due as per usual. However, if grant occurs after 36 months from the international filing date, then the patentee is entitled to a 6-month period from the date of grant within which to pay any renewal fees that would have been due on that application during the pendency of the application. But furthermore, the patentee is also allowed the additional 6-month period from that date, as would be the case in terms of the previous provisions of Section 46.2. So you basically have an additional year from the date of publication in the Patent Journal of Acceptance to pay the renewal fee if grant occurs more than 36 months from the international filing date. Okay, so it is quite a mouthful in the regulations, but I've tried to set it out as succinctly as possible. Again, you can have a look at the timelines there for your interest, just to have a better understanding of that. I think I have set it out quite clearly, so we can then continue to move on to the next section. Are there any questions on renewals at this stage? Hi, Constance.
Hi, Marco. Just to make sure that I understood what you said, do you mind going back to the previous slides?
Okay. This one here.
The previous one.
Okay.
Yes. So I wanted to make sure in a situation where somebody asks for more time, like grace period of 6 months after the first renewal date is due. If they get to pay their renewal fees 6 months after the first due date, their second renewal date, is it going to be counted from the 6 months or from the actual first renewal date?
No, so it still retains the same date. So if you see, yeah, the first renewal fee was due, say on 10 January 2003. The second renewal fee will still be due on 10 January 2004, irrespective of requesting this grace period, yeah, within which to renew. It doesn't shift the date forward for the second renewal fee. So it's still due annually on its anniversary. Yeah.
Thank you.
Okay. Pleasure. Okay, then I think we're ready to move on to the next section of our workshop, and that being the corrections and amendments. So in terms of Section 50 of the Patents Act, the registrar is provided with the authority, and not just the registrar, the commissioner as well, is provided with the discretion to allow 2 types or 3 types of errors actually, where they can make a correction. The first being that of a clerical error, secondly an error in translation, or where there is no express provision provided for in the Act. In terms of the amendment provisions, then a correction may be allowed in that, in terms of Section 51, subsection B. So if we have a look at Section 50's wording, it says the registrar or the commissioner may authorize the correction of any clerical error or error in translation in any patent, application for a patent, or document lodged in pursuance of such an application or in the register. So there are various corrections that are allowed, being that of a clerical error or an error in translation, and for various types of documents. It's either for the patent itself, the application documents for the patent, the specification, or any other document that's lodged in support of that application. The register may also be corrected in terms of the provisions of Section 51, subsection A. What is a clerical error? We will touch on that shortly. And then Section 51, subsection B also provides for the amendment of any document for the amending of which no express provision is made in this Act. And I'll give you a scenario of where that might be relevant. But if we have a look at an error in translation, you know that oftentimes these applications stem from abroad, where they have been filed in their own country in a different language other than English, and then the translator, in translating the specification into English, may have made an error in that translation. And that is where you would then rely on the provisions of Section 51, subsection A, to correct that error in translation in the specification. Where Section 51, subsection B may be applicable is, it happens quite often in practice that I deal with, is at the time the application is filed and the inventors are listed, it does happen in practice that oftentimes an inventor is not listed on the application. And there can be 2 reasons for that. The one could be that it was a clerical error, so it was just an erroneous omission on part of the secretary or person that prepared the application, and the inventor wasn't listed when they should have been listed. Or it later transpires after the application was already filed that another party should actually have been listed as an inventor for that application, because during an inventor analysis, it is then determined that there is an inventor that contributed to the subject matter that is disclosed in the patent specification. And it was not known at the time that the application was being prepared that another party had actually contributed to that subject matter. And this inventor is later identified as an inventor and should then be added as an inventor to the application. Now, in that case, you can see that it's not a clerical error. It wasn't an omission or an act that some person had permitted or omitted. And in that instance, you would rely on the provision of Section 51B that allows for the amendment otherwise of any document for the amending of which no express provision is made in this Act. So I hope that clarifies the distinction when you would rely on a clerical error or in an instance where it would be an amendment as opposed to the correction of a clerical error. And the reason why it's important to make these distinctions is because in your request to the registrar at the Patent Office, you need to stipulate on which provisions of the Act you are relying on. So you need to make a clear distinction between these two. And I mean, it can easily happen that an agent that you're dealing with in a foreign country will tell you that an inventor was erroneously omitted. Just because it was erroneously omitted doesn't necessarily mean that it's a clerical error. So you have to go on a fact-finding mission and obtain reasons as to why that person was not listed as an inventor so that you can make the correct determination on which provisions to rely on in terms of Section 50 of the Act. Also importantly, when we consider the registrar or the commissioner, that you need to make a distinction between these persons. There are two different people. The registrar is the administrative head at the South African Patent Office that is authorized in terms of the Act with certain functions and discretionary powers. The commissioner is not the commissioner of the CIPC, it is the commissioner of the court. So the commissioner of the court of the commissioner of, sorry, tongue twister, yeah, the commissioner of the Court of Patents. And that is an appointed High Court judge that is based in the Pretoria High Court. So one of the High Court judges in Pretoria are appointed as the commissioner of the Court of Patents. So these are two separate people, okay? And you need to be able to distinguish when they have a function to play in the patent landscape. And you'll also see when it comes to, the revocation of a patent or the restoration of a patent, that these persons have different functions and who is actually entitled to make a decision. Is it the registrar or is it the commissioner of patents? So just keep that in mind, please. Also bearing in mind that it is only the Court of the Commissioner of Patents that has jurisdiction in South Africa to hear patent matters. And as I said, that is the High Court in Pretoria. So it's a specialized court of the High Court in Pretoria that has jurisdiction to hear any patent-related matters. Okay, then if we consider what is a clerical error in accordance with Section 51, subsection A, there are a few cases that have dealt with what a clerical error is. The first being the case of Macaulay Corporation versus Brickcore Precast. And yeah, it was held that it is a careless error because it is unintentional, and that is then deemed to be a clerical error. It would still be a clerical error if the error was inadvertently made in an earlier draft and was then unintentionally transferred to a later draft. So this is basically just stipulating that it is something that has occurred unintentionally and which is wholly careless. That is then considered to be a clerical error. The second case is that of Hokuriku Pharmaceutical versus Cipla MedPro. Here it says that a clerical error occurs where a person, either of his own volition or under the instructions of another, intends to write something, and again, by inadvertence, either omits to write it or write something different. So again, it is an omission. There is a slight departure from the previous ruling in that it says that an error made in the course of a mechanical process, even out of sheer ignorance, is considered a clerical error. So if a person is just typing something across from a previous draft, that would likely be considered a clerical error. So where there's no, thought process being applied. Then we have the third case of Pfizer Limited and another versus Cipla MedPro. And yet it was said that the error in claim 24 was a mindless error made through inadvertence and clearly falls with the dictum in Macaulay's case. So Pfizer then again reiterated what a clerical error is, basing their finding on the Macaulay case. So in order for an error to be considered a clerical error, it is an error that must have been made carelessly, inadvertently made, either in writing or copying or in a mechanical process. So basically combining the three different findings of the courts. Then moving along to amendments, Section 51 makes provision for various types of amendments. The first being the amendment of a provisional application, the amendment of an application prior to grant, so while a patent application is still pending before the patent office, then also the amendment of a patent after grant, and then lastly, the amendment of the patent in the course of legal proceedings. So those are the four instances in which an amendment may be sought. So either it's a provisional application, an amendment before the application proceeds to grant, then the amendment after grant, and then also an amendment that sits before the court. In terms of Section 51.1 Regulations 52 and 53, these are important to note. In an application for an amendment, it is necessary to set out the nature of the amendments and to provide full reasons for any amendment made. And that is then applicable in any instance where an application for an amendment is made. So any of the four scenarios above, you need to comply with those requirements as set out in Section 51.1 and Regulations 52 and 3 by setting out the nature of the amendments and by providing full reasons for any amendment made. Now, how do you go about setting out the nature of the amendments? It's basically relying on the track changes functions in Microsoft Word, where anything that is being deleted from the specification is struck out, and anything that is being inserted is either written in red pen or annotated as an inserted section. And it's as simple as that. It is just setting out in reds and cleans what those various changes are. And then you also, in the application for the amendment, are required to provide full reasons for any amendment made. And those need to be the true amendments, as has been held previously in case law. So you cannot just rely on precedents. You need to set out the reasons why you are making these amendments to the specification. Various examples, one being that it has come to light in examination in another country that claim 1 was found to be not novel, and you're therefore amending claim 1 to introduce a novel feature that is included in one of the claims later on in the specification. So if claim 1 is found not to be novel, but say claim 3 does have a novel feature, then in order to remove the invalidity, you will amend claim 1 to include that novel feature of claim 3 in it, and then remedy any invalidity. And that would be the reason for making that amendment. Section 51. Sorry, Hans, you have a question?
Yes, good morning. In terms of, in the case of, say, in mechanical drawings, you have a feature that is there. It might not have been numbered, and then in the drawings, but then it's not mentioned in the specification. Can you make an amendment on that?
You'd need to make an inquiry as to why that image was not numbered, or that there was something that arose. And in that instance, it's very likely going to be a clerical error, where it was, again, something that was just inadvertently, mindlessly omitted in preparing that drawing. And you can then rely on the provisions of Section 50 to include that number into the drawing.
Okay, thanks.
Okay, pleasure. Okay, then if we look at the amendments for provisional applications, Section 51(5) provides that for provisional application, you can only make an amendment that corrects a mistake, which includes an obvious mistake, and that is the only type of an amendment that is allowable for provisional application. So it's to correct an obvious mistake. And that would then be obvious to a person that is skilled in that technology. So if there was, sorry everyone, just give me one moment. Sorry everyone for the abrupt interruption. Okay, if we then move on to Section 51(6), Section 51(6) provides for the amendments of a pending patent application, and this is probably the amendment that most applicants rely on. The reason being is that the requirements to make this amendment are less onerous than once the application proceeds to grant. So it is easier to make an amendment for pending application as opposed to one that has already proceeded to grant. And that is why, especially in South Africa, a lot of applicants choose to delay or extend the acceptance deadline to ensure that their application doesn't proceed to grant, so that when they have a favorable outcome in another examining jurisdiction, they can introduce any amendments made in the foreign applications into South Africa whilst the application is still pending. But Section 51(6) provides for the requirements and what amendment is not allowed when making an amendment to a pending patent application. So it states that no amendments of a complete specification will be allowed if the amendment introduces new matter or matter not in substance disclosed. So you cannot introduce new integers or new subject matter into the specification that was not previously already included in the specification. So you are not then entitled to greater rights than what you would have been before making that amendment. Then the specification as amendment would include a claim which is not fairly based on subject matter disclosed in the specification before the amendment. So whatever amendment you make to your claims has to have fair basis in the description of the specification itself. So you cannot have matter in the claims that differs from the disclosure of the specification. So those are the two requirements when making an amendment to a pending patent application. And pending application, it doesn't mean before acceptance, it means before grant. So you have up until grant to make any amendment to the specification, provided that it doesn't introduce new matter and provided that there is fair basis for any amendment made to the claims. Then when we look at the provisions of Section 51(7), it also provides that any amendment made to a granted patent may not introduce new matter. So the same requirement as for pending patent application. And again, the claim must also be fairly based on subject matter contained in the specification. So yeah, you also cannot have subject matter in the claims that differs from what is described in the description of the specification. So those two requirements are the same as for a pending patent application. But then there is an additional requirement, and that is that the amended claims must fall wholly within the scope of a claim included in the specification before the amendment. So that means that you cannot broaden the scope of protection in your claim. You can only narrow the scope. So you cannot introduce an amendment that would diminish or sorry, would increase the monopoly that you are seeking. You can only decrease the scope of protection. So you can only decrease the monopoly of the protection that is sought by the claim. Okay, so the three requirements for granted patent is that you're not allowed to introduce new matter. There must be fair basis for the amendments to the claim, and that the amended claim must fall wholly within the scope of the claim before the amendment was made. So you cannot add to the claims, you can only take away. Or an amendment of a granted patent, there is the additional requirement that the amendment of the patent after grant must be advertised in the patent journal. So if in the examination I ask you to discuss the requirements for an amendment relating to a granted patent, you'll need to provide these requirements. You'll need to set out that you need to provide the full reasons for the amendment. You need to set out the nature of the amendment. That for granted patent, you also need to advertise the amendments. And the reason why it is advertised is that any post-grant amendment is open to an opposition period. So any third party may oppose the amendment, and they have a 2-month window within which to oppose an amendment from the date of the publication of the amendments in the patent journal. Okay. Then importantly, who will hear the opposition proceedings? That is the commissioner of the courts of the Commissioner of Patents. That will then hear the opposition to the amendment, and after the court considers the opposition and hearing the parties will then make a determination as to whether that amendment is allowed or whether it is to be rejected. Okay, so that is why I say it is far more onerous on a patentee to make an amendment after grant. Number one, you can't broaden the scope of the claims. Number two, you need to arrange for the publication of the amendments for an opposition period of 2 months. So there is the possibility that any third person can oppose that amendment, and it may not be allowed. Then, as we know, there's also a fourth opportunity for an amendment to be made, and that is in terms of Section 51(9), and that is during the course of legal proceedings. So if during an infringement proceeding or during revocation proceedings before the court, if it is determined that there is an invalidity in the patent or partial invalidity in the patent, then the patentee is afforded an opportunity to make an amendment to remedy that invalidity. Again, that is during court proceedings before the commissioner of the court. So if we just have a look at the wording, it says where any legal proceedings involving a patent or a patent application are pending, any application for an amendment of that patent or application must be made to that court where it is during those legal proceedings. Section 51(10) also provides the commissioner of the court of the Commissioner of Patents to make any determination on any amendment that has been made, whether it's pending or granted, and anything that is in conflict with Section 51, the Commissioner may set aside that amendment if it was allowed by the registrar. Any questions regarding amendments? The formal documents that are used in applying for these amendments also differ. just for your information, I won't ask you that in the exam, but for an amendment made before grant, it is on a Form P12 that the amendment is requested, and then for a post-grant amendment, it will be on a Form P13. Okay, whilst we're still on Section 51 of the Act, we'll have a closer look at Section 51, subsection A, 8 and Regulation 52. And Section 51.8 provides for a supplementary disclosure. Now, what a supplementary disclosure is where you want to add new subject matter to the specification that would not be allowed by way of an amendment. So where an amendment may not be allowed by reason of the prohibition imposed by subsection 6A, so as we now know, that is not to introduce new matter, but it describes matter which may be fairly associated with the matter described in the specification as framed. So this new subject matter that you're adding must be fairly associated with the description that you have already lodged at the patent office. Then you are able to make a request for the introduction of that new matter by way of a supplementary disclosure, provided that the application has not been accepted yet. So a supplementary disclosure can only be made before the acceptance of an application to introduce the new subject matter. So if we have a look again at what is set out on the slide, it says the new matter may be introduced by way of a supplementary disclosure attached to the specification and dated with the date on which the application for amendment is made. So that's the date on which you are submitting the request for the supplementary disclosure. Provided that in determining the validity of the patent under this Act, regard shall be had to the priority date of the new matter introduced by way of the supplementary disclosure. So that's very important to note, is that the new subject matter that is added to the specification does not benefit from the priority date of the application as filed. It will only benefit as a priority in respect of the new matter from the date of filing the supplementary disclosure. So what has already been disclosed in the specification benefits from the priority application's filing date, but any new matter that is added is considered, that new matter's priority date is essentially the date on which that supplementary disclosure was lodged at the patent office. Okay. So you can see it is similar to a patent of addition where you can obtain a patent for a modification or improvement to a specification as well. However, a patent of addition can be made at any time prior to grant or after grant, whereas a supplementary disclosure to introduce new matter that is fairly associated, that needs to be lodged before the acceptance of an application. And also a patent of addition receives its own official number, so it's considered its own patent, although it is inseparable from the independent patent. The supplementary disclosure is just an inclusion into the specification itself, an addendum to the specification. Okay, then I did touch on this slide yesterday when we were having a look at the PCT timeline, where I mentioned that the Article 19 and Article 34 amendments, so those are the amendments that are made in terms of the international phase, are deemed to be amendments allowed in South Africa. So again, any amendment made during the international phase is deemed to be an amendment made in South Africa, and that is provided for by Section 43, uppercase F3M. Then Section 52 also provides the registrar with the authority to make any rectification in the register itself. So the registrar may order the register to be rectified by making, amending, or deleting any entry in the registrar, and they can do that out of their own without any instruction from an applicant. The registrar is able to do that, or they can do it upon request from an applicant. But if the registrar does it out of their own accord, then they do need to notify the applicant or patentee of the rectification that they are making. And that brings us then to the end of corrections and amendments. So then we'll have a look at some of the rights in and to inventions and patents, and maybe somewhere where we should have started off first at the procedural aspects is that who can actually apply for a patent right. And in terms of section 27(1), it says an application for a patent in respect of an invention may be made either by the inventor or any other person acquiring from the inventor the right to apply. So where the inventor has transferred their rights to a third party, then that party is able to apply for an application for the patent. And how are those rights then transferred from an inventor to a third party? We did touch on this yesterday as well. We said it can either be by a way of a contractual arrangement where there is a deed of an assignment of the invention. So the inventor contractually agrees to assign the invention to a third party, or it could be by way of a contract of employment where your employment contract stipulates that any development of intellectual property is the property of the employer. There's also a contract to do something, so where you are outsourcing a third party to do some developments on an invention, and that contract stipulates that any IP rights are assigned to the person that is instructing the work to be performed. There are also some statutory provisions that provide for the automatic assignment of rights, and there you can have it the Intellectual Property Rights from Publicly Funded Research and Developments Act. So some work that is performed by the CSIR, for instance, that those developments belong to the CSIR and not to the inventor or employee. Then also the legal representative of a deceased inventor. So if an inventor has passed on, then according to the definition of how that person's estate has been wound up, or in terms of testate or intestate succession, those rights to the invention, because bearing in mind that an invention is an asset, then those rights would have transferred. And then it's also possible for an inventor and an assignee to be jointly listed as applicants, but then the inventor would not have assigned all of their rights. They would have only assigned a share of the rights in the invention to an assignee. In all of these instances where you are required to provide proof of the chain of entitlement to the applicant, you need to provide evidence of each transfer that has taken place, whether it be by operation of law or by employment or contractually. The Patent Office has previously issued practice directives to stipulate what proof they will accept in certain scenarios. A confirmatory deed of assignment is also acceptable. So a confirmatory deed of assignment is merely just a confirmatory declaration that is signed by an inventor to state that they have transferred their rights by way of employment or any other way, if their employment contract is silent on the issue of the assignment of IP rights, because then it would come down to common law. But the Patent Office does need proof of that assignment taking place. You also have to be very careful in instances where you are dealing with foreign applicants and foreign inventors that are filing an application in South Africa, bearing in mind that their laws are different, and it might be that the rights have not transferred from an inventor automatically. For example, in America, it's the case that just because there is an employee-employer relationship does not mean that the employer is the owner of that invention. So you need to be very careful to just assume that the rights have transferred. And then you can sit in a situation where the patent can be revoked because the patentee was not entitled to that invention because the rights have not successfully been transferred. And this has happened on many occasions, and I think most notably recently regarding CRISPR technology. And anyone that's in biotech would know that that is probably a multi-billion-dollar industry at the moment and used in so many forms of biotech technologies. Okay, so very important to make sure that whoever is filing the application for the patent is actually entitled to that invention. Any questions? Okay. So now we'll look at section 29 that deals with joint ownership of applications. So just make the distinction that this is where we are referring to the ownership of an application, not the ownership of a patent, which is the granted right, or the ownership to an invention. These are all different types of rights. So section 29 deals with the joint ownership of applications. So that is where you have more than one applicant for that invention. So it could be that two companies collaborated on the invention, that they are both entitled to share in the profits of that invention. But section 29.1 states that if there's no agreement to the contrary, joint owners have equal undivided shares in the application, and none of them may deal in any way with the application except to save the application from becoming abandoned without the consent of the other joint applicant or applicants. So no joint applicant may in any way deal with an application without the consent of the other party. So it is not possible for one party to assign the rights to the invention without the consent of another party, for example. It is also not possible for one applicant to enter into contractual arrangements, perhaps for licensing of the technology, without the other party consenting to that agreement. The only time where consent is not required is to save the application from becoming abandoned. So that is where an action needs to be taken on the application to ensure that it is in an enforceable form once it does proceed to grant. So you can pay the renewal fees on an application without the consent of another, as an example. Then if there are any disputes as to the respective rights of the applicants, as to which party has what share of the rights in the invention, or any such dispute that may arise between the applicants, those would then need to be addressed to the Commissioner of the Court of Patents to hear the matter in dispute. So then it becomes a litigious matter. The person that is making the application to hear for the dispute before the court is liable for the costs and expenses. The Commissioner may order that the rights to any joint application be assigned, provided that where it appears to the Commissioner to be just and equitable, and then he may order that compensation be paid to the assigner. So if there are two applicants for an application, and the best resolution before the court is for one party to assign the rights to the application to the other party, the Court of the Commissioner of Patents may order that those rights be assigned. And if he deems necessary, that the assigner, so the party that is transferring their rights to the other, must then be compensated for the assignment. Unless good reasons to the contrary, the Commissioner is to resolve a dispute in a manner which will lead to the preservation of the application and the grant of the patent. So any dispute before the Commissioner and also before the Registrar, as a matter of fact, must always be dealt with in a way in which those rights are preserved and that it eventually leads to the grant of a patent. So ideally, the Commissioner should not allow an application to go abandoned or to become lapsed. So there must be action taken in which those rights are preserved and that there is an eventual grant of the patent. Then where there is a dispute as to the invention, so you'll recall that Section 29 dealt with the dispute of an application. Section 28 deals with a dispute relating to an invention. So where any dispute arises between the persons as to their rights to obtain a patent or to make an application, so on and so forth, any such party may apply to the commissioner to decide the matter in the dispute. So again, the commissioner of the Court of the Commissioner of Patents has the jurisdiction to hear matters relating to a dispute over the entitlement to an invention. Then if the commissioner is satisfied that a person not being obliged thereto is unable or unwilling to exercise his right to participate in an application for a patent, the commissioner may order that a person execute an assignment. So again, as we saw in the terms of the provisions of Section 29, that same provision sees itself here in Section 28, where the court can order one party to assign the rights to the invention to another party. And again, the compensation may be payable to that party that is assigning their rights. Then in any order declaring that a person has a right to the exclusion of any other person to apply for a patent, the commissioner may direct that such other person execute any deed of the assignment that may be required, and that deed of assignment extend to countries outside of the Republic. So in that deed of assignment, it may be ordered that the party assigning their rights must ensure that the assignee that is receiving the assignor's rights is permitted to then apply for applications worldwide. So any country outside of the country of South Africa. Then we also have a scenario where there is a dispute between joint patentees, so where there's co-ownership of a granted patent. Again, as with the provisions of Section 29, if there's no agreement to the contrary, each patentee is entitled to an equal undivided share in the patent. Again, if there are any disputes between the patentees, this will be heard before the commissioner, and then also they may not deal with the patents in any way without the consent of the other, except to save the patent, so paying any renewal fees. So again, a near copy and paste of Section 29, but dealing with the situation where it is ownership of a patent. Then continuing on to joint ownership of patents, if they in any infringement proceedings damages are awarded to a plaintiff, he shall be awarded damages if he were the sole patentee, and the defendant shall not be obliged to compensate any other patentee in respect of the infringement in question. So it is possible for a patentee to institute proceedings, infringement proceedings on their own without the other patentee, but they do need to seek that patentee's consent, or at least notify them. They don't require the consent, but they must have notified them of their intention to seek infringement proceedings. So if you have a look at the second slide there, the second bullet, it states that any joint patentee may institute proceedings for infringement and shall give notice thereof to every other joint patentee. So it's not necessary that they need to consent to the infringement proceeding, but there is an onus on the party that does wish to institute proceedings to notify the other patentee of their intention. They then have the decision to either intervene as a co-plaintiff, but if not, the proceedings will continue as if there is only one patentee. Okay, so we've dealt with the disputes, and then also the assignment of the patent, so very similar to Section 29. So you can have a look through all the provisions of Section 49. The largest difference is when it comes to the infringement proceedings. Okay, so still dealing with the rights to an invention and a patent, Section 59 does permit that the rights to a patent may be assigned. So it states that the rights vested in a patentee or an applicant for a patent shall be capable of an assignment and of devolution by operation of law. So those rights can be transferred, and by devolution by operation of law, that would be in the instance where it is the patentee has passed on, as an example. Then in terms of succession, those rights will transfer to whoever the heir is of the patentee. And also it's Section 59(1) doesn't just relate to a patent, it relates to an application for a patent as well that is capable of being transferred, where the ownership to that patent or application may be transferred. Very importantly, Section 59 subsection 2 stipulates that any condition in a contract of employment is null and void if the employee is required to assign to his employer an invention made by him otherwise than within the course and scope of his employment. So you cannot have a clause within an employment contract that requires the inventor to assign an invention that is not within the scope of their course and employment. You also cannot have a condition in a contract of employment that restricts the right of an employee in an invention made by him more than 1 year after the termination of the contract of employment. So if an employee has left their company's employment, anything that they have developed after a year of their termination of their employment cannot be signed to the Okay, then having a closer look at Section 61 that still deals with the assignment of the patent. When it comes to an application or a patent, those rights need to be assigned by way of a written assignment. So it cannot be a verbal assignment. The Patents Act requires that any assignment of an application or patent must be in writing. Then the Act also provides that the change of ownership may be recorded in the patent register to ensure that the register is correctly reflecting the ownership of the patent or the application for a patent. And if it is not so updated in the patent register, then it is not valid against third parties. So if any proceedings need to be taken on that patent, such as an infringement proceeding, the owner, in terms of the contract for that patent or the assignment for that patent, cannot institute proceedings until the register is correct. So it is, although it's not mandatory to record the assignment, it is advisable for that assignment to be recorded so that any action can be taken against a third party when it arises. Also importantly to note that if the assignment is not recorded within 6 months of the effective date of that assignment, then condonation needs to be sought from the patent office to allow the late recordal of that assignment. So you have a 6-month period within which to record an assignment. If not, then you need to make an additional application requesting condonation for the late recordal of an assignment. Then having a look very briefly, you can touch on this yourselves. I'm not going to go into too much detail, but Section 60, subsection 2 up to subsection 6 does provide for the attachment of a patent and also for the hypothecation of a patent. So where it is attached as security for some costs, it is possible to attach a patent, and it is also possible to offer up a patent as security for a debt. But you can have a look at the specific requirements in terms of those provisions of the Act. This then brings us to the next section of licenses, but we have been going for about an hour and 10 minutes already. So I think let's take a 15-minute break and then resume at 20 past 10. Okay, so just a short 15-minute break, and then we'll continue at 20 past 10. Thank you, everyone. Okay, welcome back, everyone. Are there any questions regarding the topics that we've discussed thus far this morning? Okay, it seems not. So then we'll move on to the next section, which is licenses. We'll first discuss compulsory licenses, and there are two instances in which a compulsory license may be sought from the Commissioner of Patents. That is, firstly, where there is an abuse of the patent rights, and then the second instance where a compulsory license may be granted is where it is a dependent patent. So if we have a look at section 56, it states that any interested person who can show that the rights in the patent are being abused may apply to the Commissioner in the prescribed manner for compulsory license under the patent. Now, when is a patent being abused? And just also note that it's not any person that can apply for a compulsory license where there is an abuse of rights. The person must have an interest in that patent. So any interested person who can show that those rights are being abused can apply to the Commissioner. Also just important to note that the application is made to the Commissioner of the Court of the Commissioner of Patents. Then section 56 subsection 2 provides for instances in which a patent right is considered to be abused, and the applicant that is interested in obtaining a compulsory license will need to prove one of these instances. So it's not necessary to prove all of them, but they must show that there is an abuse of the patent rights in terms of either one of the following provisions. And that is that the invention that is patented is not being worked in South Africa on a commercial scale or to an adequate extent after the expiry of a period of 4 years subsequent to the date of application for the patent, or 3 years subsequent to the date on which the patent was sealed, so whichever period last expires. And there is, in the opinion of the Commissioner, no satisfactory reason for such non-working. So this is where somebody has a monopoly right over an invention, but they're not actually utilizing that invention. So there's the invention is not being worked on a commercial scale or to an adequate extent, then that patent right may be considered abuse if there's no reason for the non-working of the patent. Then the second provision was deleted by an amendment to the Patents Act, but then moving on to the next instance where a patent is considered to have being abused is that the demand for the patented article in South Africa is not being met to an adequate extent and on reasonable terms. So there's an increased demand for the invention, but that demand is not being met by the patentee. Then an additional instance where there may be an abuse of rights by reason of the refusal of the patentee to grant a license or licenses upon reasonable terms, the trade or industry or agriculture of the Republic, or the trade of any person or class of persons trading in the Republic, or the establishment of any new trade or industry in the Republic is being prejudiced, and it is in the public interest that a license or licenses should be granted. So in this instance, you can see that the person would have had to have sought a license from the patentee, and if no and if the patentee then refuses to award a license and they are unjustly doing so where there is prejudice to the public, then it is possible to obtain a compulsory license. Then the additional point on which a patent may be abused is if the demand in the Republic for the patented article is being met, but it is being met by importation and by a price that is excessive. So the demand in the Republic for the patented article is being met by importation, and the price charged by the patentee, his licensee, or his agent for the patented article is excessive in relation to the price charged in other countries where the patented article is manufactured by the patentee or under license from the patentee or his successor in title. Okay, so the demand is being met in South Africa, but is by way of importation, and the price being charged is excessive in comparison to the price charged in the country that it is coming from. To my knowledge, there's never been a compulsory license granted in South Africa. There have been applications made for compulsory license have either been unsuccessful, or the parties have agreed to terms outside of court and settled on a license after that application for compulsory license was made. So the proceedings were then cancelled. So never a successful compulsory license that has been granted in South Africa. As you can see, it would be quite onerous on an interested party to prove that there is an abuse of rights. And yeah, I mean, even though the government, as an example, also has the opportunity to rely on the provisions of a compulsory license in the instance of pharmaceuticals, as an example, if you consider the COVID pandemic and the need for the COVID jabs, there probably could have been reliance on the government to obtain a compulsory license in terms of the subsection D over here, where it is in public interest that a compulsory license be granted for the vaccination for COVID. But apart from these provisions where there is an abuse of rights, the government does also, in other sections of the Act, also have the provision to expropriate a patent right where it is in the public interest to do so. If the party is not willing to come to, and if the patentee is not willing to come to terms with the government to be able to obtain the rights to the patent, then it will be to the court's discretion to make a determination if what grounds would be reasonable for compensation to be paid to that party. So there are other provisions that the government can rely on. During COVID pandemic, unfortunately, I don't think the government relied on any of these patent provisions to obtain licenses for the vaccination. But it does exist, and not only in terms of the provisions of Section 56. You'll see that one of the articles that I did distribute to you does deal with the rights of the government in obtaining the rights to an invention for their use where it is in public interest. So you can have a look at that as well. Then further provisions from Section 56 is that the patentee or any other person appearing from the register to be interested. So that could possibly be a licensee. So where someone has licensed the use of the patent and the invention, they may oppose the application for a compulsory license. The Commissioner shall consider the application on its merits and may order the grant of the applicant of a license on such conditions as he or she may deem fit, including a condition precluding the licensee from importing into the Republic any patented articles. If the Commissioner is of the opinion that an order directing the grant of a license is not justified, he may refuse the applications. Then a license granted under this section shall include a provision that, subject to adequate protection of the legitimate interests of the licensee, the license shall, on application by the patentee, be terminated if the circumstances which led to its grant cease to exist, and in the opinion of the Commissioner, are unlikely to reoccur. So the license agreement will cease to exist if what led to that abuse of rights has been addressed by the patentee. then the license that is granted is a non-exclusive license and shall not be transferable except to a person to whom the business or part of the business in the connection with which the rights under the license were exercised has been transferred. So it's a non-exclusive license, so the patentee is permitted to enter into additional license agreements with third parties, and the compulsory license is not transferable from one party to another unless they are related entities. In determining the conditions on which any license is granted, the Commissioner shall have regard to any relevant facts, including the risks to be undertaken by the licensee, the research and development undertaken by the patentee, and the terms and conditions usually stipulated in a license agreement in respect of the subject matter of the invention between persons who voluntarily enter into such agreements. So this provision just provides for the things that the court needs to consider when making a determination as to whether a compulsory license should be granted. The Commissioner may order that a license granted in terms of this section shall be deemed to have been granted on the date on which the application has been received by the registrar, and any order of the Commissioner under this section shall be made with a view to avoid the abuse found by the Commissioner to have been established. The Commissioner may amend or revoke any license granted under this section. Subject to the conditions that may be attached to the license, a licensee under this section shall have the same rights and obligations as any other licensee under a patent. So there cannot be prejudice to the licensee that has sought for the compulsory license. The Commissioner may, when ordering the grant of a license, award costs against the applicant or patentee concerned or any other person opposing the relevant application. They have to have regard to the nature and extent of the abuse found by him to have been established. This is when considering a costs award, and whether the application for license under the section might have been avoided by the grant by the patentee concerned to the applicant if a voluntary license was entered into on reasonable terms. For the purposes of the section, the expression patented article includes any composition of matter or any product of a patented process or method, or any product produced by a patented machine. Okay, so that brings us then to the end of the scenario where compulsory license is sought, where there is a consideration for an abuse of rights of the patent itself. Any questions on an abuse of rights? Isaac, you have a question?
Yes. Morning, everyone. Yes,
Morning,
Marco. Yes, I have one question based on the compulsory licenses. So,
okay.
What's the difference between relying on Section 31B of TRIPS and also what's the difference between relying on Section 56 of the compulsory license as well as also Section 31B of the TRIPS article?
21B. 21B, if I remember correctly, is the relaxation of the TRIPS flexibilities.
Is 31?
I need to have a what 31?
Yes.
Okay, I need to take a closer look at that for you, but from what I can remember is that allows for certain flexibilities where it is a developing country to be able to use an invention without the consent of the patentee. And you can correct me if I'm wrong here. However, for those TRIPS flexibilities to be applicable, they still need to enter into a national law. And South Africa has never utilized those TRIPS flexibilities. So in order for any international agreement to have effect, it needs to be nationalized into South African law in terms of international law itself and the provisions of international law. So those TRIPS flexibilities have never actually formed part of South African national law, and therefore South Africa can't rely on those provisions unless they actually introduce it into South African legislation. But I'll have a closer look at that and get back to you with a response. But that is my very rudimentary understanding of those TRIPS flexibilities insofar as they relate to South Africa.
Okay. No problem.
And I mean, as I said as well, I don't even think South Africa needs to rely on those TRIPS flexibilities, because there are various other provisions made for in the Patents Act. And if I have a look at the top of my head, you've got Section 78. I'm having a look at the Act in front of me at the moment. Yeah, so Section 78 states that the minister may be, on behalf of the states, acquire on such terms and conditions as may be agreed upon any invention of a patent. So there is the possibility for the state to expropriate the rights into a patent or the invention. However, there needs to be an agreement between the parties. But then it is also possible, in terms of Section 79, for the assignment of certain patents to the state as well, where it is in public interest. So you can have a look at those provisions in the Act as well. The entire chapter deals with the acquisition of rights to inventions and patents by the state.
No, thanks, Marco.
Pleasure. Hans, your hand is also up.
Thanks, Marco. This is just a question, like a generic question. It has nothing to do with this. Where do you see South Africa going with examination, and do you think we are ready to tackle it? Do you think we can tackle it anytime soon, or maybe we might need to do more if the act comes to pass?
Look, if the act comes to pass, and I haven't had any sight of the draft legislation, so I don't really know what the proposed bill includes. But if it only includes the introduction of substantive search and examination, then I think we are still a way off. And the reason being is that is not enough just to stipulate that South African applications need to be examined substantively. There have to be the regulations that speak to the Act, that provides for, what actions are taken at certain steps. So more the procedural aspects relating to examination. And again, I'm not sure where government is with regards to drafting of suitable regulations. And then also, having clear examination guidelines, not just for the examiners, but for applicants as well, to understand what it is, or the manner in which examination is being conducted, and what the public needs to be aware of in terms of examination. How does the Patent Office deal with inventions that are generated by AI, as an example? In a lot of other jurisdictions, there are guidelines, such as the EPO, for example, that have very clear guidelines what happens and what will happen if an invention comes across the desk of an examiner where it is related to an AI developed invention. So things like that, I do think, would need a bit of time to be ironed out. But as I said, I'm unfamiliar as to where government is with drafting regulations and guidelines. It's not just enough to have the act that introduces examination. You have to have everything that speaks to it and how those procedures will actually follow. I understand that the examiners have been trained extensively, from various engagements and collaborations with other patent offices. So I'm sure that the examiner's knowledge is up to speed with where it should be, and I think that they are probably equipped
You
to
reckon? No, I'm saying you reckon. You reckon we are
I,
equipped?
I don't know. Look, I mean, that's the information that I have from the liaison committee of SIPOL with CIPC.
Yes.
Um, so that's the information that I have at hand. Is that I know that the EPO has been very involved, that the Japanese Patent Office has been very involved, the Swiss Patent Office, and I mean these are all very, very good examining jurisdictions. So I'm thinking if there was training provided by them and from experts in South Africa, that hopefully the knowledge that's been imparted is what is required. And then I'm sure that the examiners have the necessary technical skills as well to understand technologies. So I think we're definitely on to summarize, I think we are on the right track. But I do think that it's not something that is going to happen within a month or two, for the reason that a lot needs to be considered. Will there be opposition periods? Will there be the possibility to oppose grants? And that's just considering how other examining jurisdictions work. But I do think that we're on the right track. Yes.
Okay, thanks, Mark.
Pleasure. What is your take?
My take on what?
Do you think that we're on the right track?
Yeah, well, most definitely. I feel like the postponement of passing the bill is actually what's delaying us because I'm an intern myself in
Okay.
examination.
Okay.
So I feel like we could do better. For instance, we have an ELP program
Yes.
um, that we're dealing with, and then where we have to send files to law firms, and then they have to respond and all that. So, and then we have some other files that we have to cover that are not ELP. For
Yeah.
instance, when I'm working on an ELP file, most especially an approved file, I would put more time on that one.
Okay.
You see, I feel like we don't really have we have the knowledge, but not really the capacity. I put more time on a serious file. So I feel like if the bill comes to pass and we do real examination, that would be more interesting because now you can no longer just say, it's fine. Anyway, it's
Dedicate
not
all your
going
time
anywhere.
to one. Yeah.
Yeah. So, like this is from my side as an examiner. I don't know about the management and what they're planning, but then from my side, I feel like let's play this, like let's do it. But then we need capacity. That's another thing. Capacity,
Yeah.
because I'm a mechanical engineer myself.
Okay.
I can't be dealing with everything, civil engineering things and all that. Some of the things I don't understand that well, and I'll end up doing less work. And I think the main issue here is to give a good work.
Product. Yeah.
And then you can't do that if you're not an expert in that field.
Yeah. Look, I think my suggestion to government would be that it either be implemented in a phased approach where examination only takes place for specific applications. So maybe where it's a South African applicant, and if it's a national phase application, that reliance is had on another examination work product. Just to alleviate this influx of a burden on examiners and the office itself to process all these applications. That is one of the ways that it can be done, so that there is still examination taking place, but on select applications only where there hasn't been any previous examination. But again, that's I don't know what government's take is on that, and I don't know what their plan is on how to implement it. But yeah, I mean, if you're looking at the EPO as an example, I mean, they've got hundreds of examiners, and I don't know, last I heard was that I think there's less than 30 or so at the patent office. I'm not too sure. So I think capacity will be a concern.
Yeah, most definitely.
Yeah. Okay, but thanks for that insight, Hans.
Thanks, Marco.
My dealing with colleagues in other patent firms, they have commended the patent office as well, and so have my colleagues, where they have received work products from the examiners, saying that the work products that they're receiving are of a high output. So I think that is very positive feedback. Okay, so we've digressed a little bit, but I think that is a hot topic, and it is important for everyone in intellectual property to know of the developments and where we are with things. So I do apologize for spending a bit of time on that, but it is an important consideration. Okay, so then we'll move on to dependent patents, which is, as I said, one of the two scenarios where compulsory license can be granted. Now, just to break it down as to what a dependent patent is, it is where, in order for the invention to function, so if I'm the proprietor of, or the patentee of this invention, in order for it to function, I am required to infringe on another existing patent. So in order for my invention to work, the working of that patent would otherwise infringe on another patent, then that is known as a dependent patent, because its operation, its functioning is dependent on another patent to successfully be performed. And in that case, if the party where you require that patent is unwilling to enter into a voluntary license, then you can seek a compulsory license to enforce them, or to force them to award you with a compulsory license. I think if you think about your cell phone as an example, the processor in the cell phone is probably one of two companies that manufacture all cell phone processors. But there are other technologies in the phone that are patented, but that require that patented process in order for that functionality of the patentee's product to actually work. And that is where it is a dependent patent. So a lot of the technology within a cell phone, as an example, is licensed, and there's a lot of cross-licensing that happens between the various companies that have components that make up the overall product that we use today. I mean, interestingly enough, I previously heard that an iPhone is more a Samsung phone because of the amount of technology that is licensed to Apple. Whether there's truth to that, I don't really know. Just a joke. But in any event, so that's just the explanation as to what I'm referring to when I talk about a dependent patent. So Section 55 provides that where the working of a patent, again often referred to as a dependent patent, without infringement of a prior patent, is dependent upon the obtaining of a license under that prior patent, the proprietor of the dependent patent may, if agreement cannot be reached as to such license with the proprietor of the prior patent, apply to the commissioner for a license under the prior patent, and the commissioner may grant such a license on such conditions as he may impose, but including a condition that such license shall be used only for the purpose of permitting the dependent patent to be worked and for no other purpose. So in order for the cell phone to work, where I need that processor, a dependent patent will be granted for the use of that processor only insofar as it relates to the use of the cell phone. I cannot now apply it to other technologies that I'm developing. Provided that the commissioner shall not grant such a license unless the invention claimed in the dependent patent involves an important technical advance of considerable economic significance in relation to the invention claimed in the prior patent. So there must be an important technical advance in the patent from the person that is seeking to obtain a dependent patent. The proprietor of the dependent patent the proprietor of the dependent patent granted the proprietor of the prior patent on reasonable terms a cross license. So there has to be a cross license of the technology between the two parties where the dependent patent is being awarded. Then the use authorized in respect of the prior patent is not assignable except without the assignment of the dependent patent. So if there's an assignment, both need to be assigned. And that covers the dependent patent. I think the explanation I gave before we read section 55 does explain quite succinctly what it is. Any questions on a dependent patent? Hans, you have a question still, or is that an earlier hand?
Yeah. Could you please, when you say the commissioner, maybe distinguish between the commissioner of the office or the commissioner of the courts, because sometimes it gets confusing. Maybe for me, I don't know about others.
Yeah, sorry. So the commissioner, when it's referred to in the Patents Act, is not referring to the commissioner of the CIPC. It's always the commissioner of the court. So the commissioner in this instance in the Patents Act will always be the High Court judge that's appointed as the commissioner of patents.
Okay, thanks.
Yeah, pleasure. Okay, then touching on section 53 that deals with licenses of rights, you'll see I haven't included the wording of section 53. You can have a look at that. But section 53 permits for a patent to be endorsed as a license of rights. And what that means is that where the patentee himself is not or herself is not working that invention and they don't see any prospects of working the invention, and there's also no appetite for that invention to be licensed, then they can endorse the patent register to indicate that that patent is a license of rights, which allows the public to then obtain a license as of rights to utilize that invention without infringing it. The benefit to the patentee of doing that is that the renewal fees that are due on that patent are then only half of what it would ordinarily cost. Renewal fees in South Africa are incredibly cheap, so there's not much of a benefit to the patentee for doing that. But please do be aware of what a license of right is. Then section 54 goes into how that endorsement of a patent as a license of right can be cancelled. And you can then just have a look at the rest of the provisions that are set out on this slide. I'm not going to go through that in this presentation. Then section 91 of the Act, also an important section for anyone dealing with IP on the commercialization aspect or, negotiation of agreements, license agreements, purchase and sale agreements and the like, to be aware of these conditions that are excluded from being used in a contract. So any of the 5 provisions provided for in section 90 subsection 1 are deemed to be null and void if they were to be included. So the first is that any condition in a contract relating to the sale of a patented article or to a license. So this is either an assignment of a particle or the sale of a patented article, or where there is a license under the patent to prohibit or restrict the purchaser or licensee from purchasing or using any article or class of articles, whether patented or not, supplied or owned by any person other than the seller or the licensee or his nominee, licensor or his nominee. The crux of this provision is that you cannot prohibit a licensee from purchasing or using any item supplied by another third party. So you cannot prohibit somebody from purchasing any other item from a third party. Then the second exclusion is that you cannot prohibit or restrict the licensee from using any article or process not protected by the patent. So that's relatively straightforward. You cannot prohibit somebody from using a process or an article that is not protected by the patent itself. So you cannot prohibit the licensee from using any item that is not protected by the patent. Then thirdly, to require the purchaser or licensee to acquire from the seller, licensor, or his nominee any article or class of articles not protected by the patent. What this implies is that you cannot force the licensee to buy non-patented items from the licensor. So number B above related to the use of any article or process, whereas C relates to the sale of the product itself. Then having a look at D, to require or induce the purchaser to observe a specified minimum resale price in respect of any article or class of articles protected by the patent. So the licensor cannot set a minimum resale price. Then lastly, to prohibit or restrict the making, using, exercising, or disposing of the invention concerned in any country in which the invention is not patentable. So you cannot restrict the licensor, the licensee, apologies, from using the invention in a country where there are no patent rights. So important to note these exclusions from contracts and license agreements. How's everyone doing? Do we need a break or are we happy to continue? Okay. There's one thumbs up, so I'll take that as consensus. So we'll move on then to restoration of a lapsed patent. So this is where the renewal fees relating to the patent to ensure that it remains in force have not been paid. You've missed the grace period, the 6-month grace period provided for in Section 48 of the Act, and the patent has then lapsed due to the non-payment of those renewal fees. What can be done in that instance to restore the patent? And this is provided for in Section 47. Section 47 states that where a patent has lapsed owing to non-payment of any prescribed renewal fee within the prescribed period or the extended period, so that being the grace period, the patentee may in the prescribed manner and on payment of the prescribed fee apply to the registrar for the restoration of the patent. So yeah, it's important to make a distinction that an application for the restoration of a patent is made to the registrar. It is not made to the commissioner. Although there is an instance where a commissioner is involved, but the initial application for the restoration of a patent where it has lapsed is made to the registrar. And then there are 2 requirements that need to be met in order for a lapsed patent to be successfully restored. And those are provided for in Section 47(2). That is that the omission to pay the renewal fee was unintentional and that there was no undue delay that occurred from learning of the lapsing of the patent to the time when the application is made for the restoration of the patent. So it's important to note those two requirements in order for a lapsed patent to be successfully restored. So if the registrar is satisfied that the omission was unintentional, so that may have been that the renewal dates were not correctly diarized, it was an administrative oversight, the patentee may not have received the renewal reminders from their agent as to when renewals were due on the patent. So those are some examples of where it would be considered an unintentional omission to pay the renewal fee, and that no undue delay has occurred in the making of the application for the restoration of the patent. Once that application is made, the registrar must advertise the application in the prescribed manner in the patent journal that there is this application that has been made to restore the patent. So the registrar must notify the public of the application for the restoration of the patent journal in the patent journal. And then any party may oppose the restoration of the patent, and that is within such period as prescribed. And if I recall correctly, it is a 2-month period on which that may be opposed. Okay, so from the date of the publication of the application for restoration in the patent journal, any party may oppose the restoration of the patent within a period of 3 months. If there's no opposition, so after that 2-month period has lapsed and the registrar hasn't received any objection to the restoration of the patent, then the registrar may issue an order restoring the patent, or they may dismiss the application if they find that the 2 requirements for the successful restoration have not been met. So where notice of opposition is given, the commissioner, so note here that if the restoration is being opposed, then it is the commissioner that deals with the opposition to the restoration. So then the powers shift from the registrar to the commissioner. And after the commissioner hears the applicants and the objector, they may decide the matter, and the commissioner may then issue an order either restoring the patent or also dismissing the application. So if there's no opposition to the restoration, the registrar has the power to deal with the restoration. If there is an opposition, then it is the commissioner that needs to decide on whether it must be restored or not allowed. Then any order restoring the patent shall be subject to the payment of such prescribed fees as remain unpaid on the dates of the order. So any renewal fees that were not paid, in order for that order to be effective, need to be paid to the patent office. Any questions? Okay. So Section 47(1), this is just a summary of what we have discussed, and when I'm referring to the prescribed manner in which the application must be made, you can have a look at regulations 49 to 51, but these provide that the application is made in the manner of an ex parte application that you would ordinarily make to the court, so that it mirrors a notice of motion as near as possible if you were making an ex parte application to the court. And then in support of the application, it must be accompanied by one or more affidavits that set out the facts. So you would need to aver in the affidavit or affidavits that the omission to pay the renewal fee was unintentional, and then you would need to provide the reasons and the facts that led to that unintentional payment of the renewal fee, and then also an averment that this application is being brought within a reasonable time, so that you are in compliance then with the no undue delay requirement. Okay, so again, just a breakdown of all the provisions that we've already had a look at in a more succinct manner for you. So if a patent is then successfully restored, what happens to the rights of the patentee of a restored patent? So their rights automatically become limited to some extent. And the reason being is, if a third party, somebody in the public, was monitoring this patent in the patent register, they would have seen that the patent has lapsed because the renewal fees weren't paid. And if it is lapsed, then any party is entitled to make use of that invention. So they may have implemented using the invention themselves, and now the patent becomes restored. So what happens in that instance? And in that case, the rights of the patentee become limited. And how they become limited is provided for in terms of Section 48. So firstly, that part, the patentee cannot institute infringement proceedings against any person that has started to use the invention. So if we have a look at the wording of the Act, it says a patentee of a patent restored shall not, by virtue of the provisions of this Act, institute any proceedings against or recover damages from any person who infringed the patent after the lapse of a period of 6 months from the date on which the renewal fee was due and before the date on which the application for the restoration of the patent was advertised. So between the period of the lapsing of the patent and from the date in which it is restored, you cannot recover damages from any person that has made use of the invention during the lapsing and the publication dates of the restoration of the patent. Or if the person has used, offered to dispose of, or disposed of any article made or imported in that same period, again, you cannot institute any proceedings against them. Then worse off for the patentee is that during that period commenced using or exercising the invention to which the patent relates, and who thereafter continues to use or exercise the invention. So even continued use of the invention once the patent has been restored, they cannot pursue infringements against that third party. And the same applies then if it uses or offers to dispose of any articles or products produced by the continued use. So if there are already products that were manufactured by the method of that invention, then they can still continue to use or to dispose of them. So quite harsh consequences for the patentee if the patent lapses and is successfully restored, because you cannot institute infringement proceedings or recover damages if there was use, the offer of the invention, the disposal of the invention, of any article made or imported. Or for the continued use thereof of any product of that invention. Then it gets a little bit worse for the patentee, because where a patent has successfully been restored under Section 47, any person who during the period referred to in Section 48 has expended any money, time, or labor with a view of making, using, exercising, offering to dispose of, disposing of, or importing of the invention may apply to the Commissioner of Patents for compensation in respect of money, time, and labor so expended. So if during the period in which the patent is lapsed, a third party begins to set up a manufacturing plant for the product of the invention, they haven't yet manufactured the product itself, but if they have taken steps to set up a manufacturing plant, then they are entitled to seek compensation from the patentee for the money, time, and labor that they have expended. Then the Commissioner may, after hearing the parties concerned, assess the amount of such compensation. and if, in his opinion, the application ought to be granted, then determine the time within which such compensation shall be paid. So he can stipulate within which period the patentee needs to pay over the compensation for any costs that the third party has incurred. Any questions? That then brings us to the end of the restoration of a lapsed patent. Okay, just give me one moment. Okay, it seems that we nearing the end of the workshop. We have revocation and infringement left that will require some attention. As I said, the appeals provisions and evidence, offences and penalties will be for self-study. Please don't think that that doesn't mean it won't be included in the examination. It is still part of the subject matter. So just because it is self-study, that does form part of the examinable material. But we have the option of either taking a short 10-minute break now and then completing revocation and infringement, or we can break later for lunch if we continue ahead now. But my preference would be to just take a short 10 to 15-minute break, and then we can finalize for today. Is everyone happy with the proposed plan? Okay, so let's rather have a short break now instead of a longer lunch, and then we might even be able to finish by around lunchtime. Great, thanks everyone. Let's reconvene then at 11:30. So we'll have about 15 to 17 minutes just for a quick break. Thank you. Welcome back. Let's dive into the next chapter for today, that being the revocation of a patent. So this is in the instance where the third party believes that there is an invalidity in the patent and then applies to the Commissioner of the Court of the Commissioner of Patents to revoke the patent. Provisions dealing with the revocation are in section 61 of the Act. Very important section to note, particularly because the grounds on which a patent can be revoked are exhaustive. So only those grounds provided for in the Patents Act are the grounds on which a patent can be revoked.
Sorry, Marco, can I interject
Yes,
you on
Hans.
that?
Yes.
Sorry. You said the commissioner of the courts or the commissioner of of the office.
No, so it's the Commissioner of the Court of the Commission of Patents.
Okay, thanks.
Yeah. So it's the court. You'll recall from when we had a look at compulsory licenses that for a compulsory license to be sought, it had to be made by an interested party. Unlike with the case for revocation, any person may at any time apply to the Court of the Commissioner of Patents for the revocation of the patent. So there's no need to show any particular interest in the patent. So any member of the public, any third party, can apply for the revocation of the patent. The application for revocation may be brought at any time from the date of grant of the patent up to the date of expiry, and even after the expiry. Why after the expiry? It might be that you are still, as a patentee, seeking damages for infringement that took place during the life of the patent. And if you are the alleged infringer, then you would likely apply for the revocation of the patent so that you are not liable for any damages that may have arisen. As I said, the listed grounds are exhaustive because of the use of the word only in the Act. So there are no other grounds on which the patent can be revoked, and this was also confirmed in the case of Busby versus the Registrar of Patents in the 2010 case. You can rely on more than one of the grounds, so you can rely on them in the alternate. There may be more than one reason as to why you are seeking to revoke the patent, and if you are unsuccessful in one of the if you are successful on one of the grounds, you might be successful on another ground. So you can rely on as many grounds as you deem necessary to revoke the patent. Importantly to note that if you as the patentee are instituting infringement proceedings, that a defendant to the infringement proceedings is permitted to counterclaim for the revocation of the patent or rely on the invalidity of the patent as a ground of defense. So do be mindful of that. If ever there is an infringement proceeding taking place, you can counterclaim as the defendant for the revocation of the patent. And if it is found that the patent is invalid, so if the defendant is successful in revoking the patent, then obviously there would have not been any infringement that would have taken place because of the invalidities in the patent. So let's have a look at the grounds on which the patent can be revoked. Please note that these are important for examination purposes as well, to stipulate what the grounds of revocation are. The first being is that the patentee is not a person entitled under Section 27 to apply for the patent. So you'll remember that Section 27 informs us as to who an applicant for a patent may be. So it's either the inventor or any person that has acquired the rights from the inventor. But if the inventor as the applicant or any other party as the applicant is not actually entitled to the invention, then the patent can be revoked. So if the rights were not successfully transferred to the applicant, then they were not entitled to the invention or entitled to file the application for the patent. So the inventor named is not the true inventor, as an example, or it was the incorrect applicants that were listed as the applicant. Then the next ground is that the grant of the patent is in the fraud of rights of the applicant or any person under through whom he claims. So this is where there's a fraud of rights. So in this instance, it would be where the conduct of the applicant is construed to deliberately deprive the person that is objecting to the patentee's rights in the invention that they were not actually entitled to, or that they defrauded the objector of their rights to the patent. So where there is a fraud of rights on the part of the applicant or any other person through whom he claims. So just remember that it's the fraud of the rights of the applicant, and in this case, it's not the applicant of the application for the patent, but the person that is applying for the revocation. So if the aggrieved party feels that their rights have been deliberately deprived by the patentee, then they can revoke the patent. Then that the invention concerned is not patentable under Section 25. So we dealt with Section 25 at length yesterday, and this is probably the ground that most revocation proceedings are based on, and the ground that's most often relied on is that the invention is not new, or that the invention is not obvious to a person skilled in the art. You can then also rely on the other grounds of Section 25, in that the invention itself is not an invention, so that it is one of the exclusions in Section 25, subsection 2, or that the claims relate to a method of treatment of a human or animal body. So all the grounds that are provided for in Section 25 can be relied on to revoke the patent. Then the next ground is that there is inutility in the patent. So this relates to the description of the invention. So, and not the claims themselves, but rather the description. So when following the description, it's not possible to perform the invention, or the description does not lead to the results or advantages. So if it is being worked, you are not obtaining the same results or advantages that you are setting out in the complete specification. So if we have a look at the wording from the Act, it says that the invention as illustrated or exemplified in the complete specification concerned cannot be performed or does not lead to the results and advantages set out in the complete specification. So the information is contained in a specification, but when performing it, you do not obtain the results that it sets out to achieve. Then the next ground, which is known as the insufficiency ground, is where there is not sufficient information provided in the application to allow somebody skilled in the art to put the invention to use. So there's details lacking from the application, so that the complete specification concerned does not sufficiently describe, ascertain, and where necessary illustrate or exemplify the invention and the manner in which it is to be performed, in order to enable the invention to be carried out by a person skilled in that art. So it is deficient in the information that is set out in the specification. Then another ground that is often relied upon is that the claims are not clear, or they are not fairly based on subject matter disclosed in the specification. Then the next ground is that the prescribed declaration, and that should be declarations lodged in respect of the application for the patent or the statement lodged in terms of section 33A. So the first declaration is your form P3 and power of attorney document. And then the second one is the form P26. Contains a false statement or representation which is material and which the patentee knew or ought reasonably to have known to be false at the time when the statement or representation was made. Okay, so we spoke about this at length yesterday as well, regarding the importance of those declarations, and if any false statement is made in support of those declarations, then the patent can be revoked. And quite onerous, because it's not just that there must have been a material representation, but even if the patentee knew or had reasonably should have known that representation to have been false, then it is possible to revoke the patent. But what is considered a material misrepresentation? So that would be any misrepresentation of facts relating to the application, and if acted on by the registrar, would result in the applicant obtaining something to which they are not entitled. So that can be any of the misrepresentations on the form P3, such as the listing of the inventors, the incorrect applicants, the incorrect priority claims, stating that there's no lawful ground for the revocation of the patent when you oughtn't have known that there is, then those are considered to be material misrepresentations. Then that the application for the patent should have been refused in terms of section 36, and those are where it is a frivolous invention on the ground that it claims an invention, anything that is contrary to well-established natural laws. So as I said, as an example, a perpetual motion machine, or the invention encourages offensive or immoral behavior contrary to law, or the requirements pertaining to nuclear energy inventions have not been complied with. So any of those instances does permit any person to then approach the commissioner for the revocation of the patent. Then lastly, that the complete specification claims as an invention a microbiological process or a product thereof, and that the provisions of section 32.6 have not been complied with. And remember that section 32.6, as we discussed yesterday, relates to South Africa's obligations in terms of the Budapest Treaty to ensure that there is a deposit of the microorganism at a suitable housing facility where the microorganism is cryopreserved. Then just a few additional points on revocation. We discussed divisional applications yesterday, and I spoke about unity of invention or objections to unity of invention, where the patent should only claim one invention, but oftentimes that doesn't happen. And you'll recall that I said there is no remedy should that be the case. And that is provided for in terms of section 62, that states that a patent shall be granted for one invention only, but no person may in any proceedings object to a patent on the ground that it comprises more than one invention. So you cannot revoke a patent if it comprises more than one invention. As I said, you might be able to argue that the claims are unclear and rely on other grounds on which to revoke the patent. If an applicant for the revocation of the patent relies on point number B over here, where they are claiming that the rights to the invention were fraudulently obtained, then in terms of section 63, the commissioner may order that the rights be transferred to the rightful entitled party. So where a patent is revoked on the ground of a fraud of rights, or a patent fraudulently obtained has been surrendered and revoked, the commissioner may, on the application of the inventor or the relevant invention, or his assignee or legal representative direct the grant to him of the patent. So the register will then need to be updated to reflect the change of ownership. And then you can have a look at section 64, which deals with the voluntary surrender of a patent. That is for self-study. Any questions on revocation? Okay, so then we'll move on to infringement. So we know that a patent is a negative right that is awarded to the patentee. And we say negative right because it's not permitting the patentee to do something, but it's rather excluding other persons from performing certain acts. And what those acts are provided for in section 45 to state what the effect of a patent is. And the effect of a patent shall be to grant to the patentee in the Republic, so remember it's a territorial right within the confines of South Africa's boundaries, subject to the provisions of this act for the duration of the patent, which we know is 20 years, the right to exclude other persons from making, using, exercising, disposing, or offering to dispose of, or importing the invention, so that he or she shall have and enjoy the whole profit and advantage accruing by reason of the invention. Okay, so the patentee is awarded the right to exclude other persons from making, so manufacturing, using, exercising, disposing, or offering to dispose of, or importing the invention. Then section 45(2) provides for the exhaustion of rights, so the disposal of the patented article by the patentee or on behalf of the patentee or the licensee gives the purchaser the right to use, offer to dispose of, and to dispose of that article as they deem fit. So once the patentee has sold the product, then the purchaser has the right to use it as they so please. Okay, so that section 45(2) provides for the exhaustion of the patentee's rights. Each of the acts that people are excluded from performing, you can have at the dictionary definitions. Those are the definitions that are applicable in this instance, should those not be clear to you. Then who has the locus standi to bring an infringement action? It will be the patentee, obviously. We also know that if there are co-patentees that own the invention and have the rights to the patent, then it is not necessary for both of them to partake in the infringement proceedings, but the party that is intending on instituting infringement proceedings must notify the other party of the intention to do so, and they then have the opportunity to intervene as a co-plaintiff. A licensee doesn't have any independent right to bring an infringement proceeding, but the patentee is required to give notice to a licensee that they are also instituting infringement proceedings. And if they do not wish to intervene, they do not have to. There's no obligation on a licensee to intervene, but they may if they do wish to partake in the infringement proceedings as a licensee. Okay, also important, you'll see that in order for a licensee to partake in the infringement proceedings, they must be recorded as a licensee in the register. So if ever a license is awarded for the patent to a third party, then that license agreement should also be recorded in the patent register, so that the licensee is listed in the register as somebody that is an interested party, and that they can then also intervene in the infringement proceedings. Okay, so if an infringement action is before the Court of the Commissioner of Patents, then the court needs to make a determination whether infringement has taken place. Again, a rather factual inquiry, and the test for determining infringement is again set out in Ensign Bickford versus AECI Explosives. And you'll recall that we touched on this case yesterday as well for the test of obviousness. The test for infringement was also provided for in the Ensign Bickford case. But in order to ascertain whether there has been an infringement of a patent, the court must decide if the act alleged to have been done by the defendant is of such a nature that it could constitute an infringement of the patent, or whether it is excusable. So when it refers to the act alleged to have been done, that needs to be one of these acts provided for in section 45(1). So is the act of making, the act of using, the act of exercising, is that action by the alleged infringer, has that been conducted? Are they performing one of those acts? Then the court needs to construe the claims to determine whether the alleged infringement falls within the scope of any one of the claims. And then, so again, to construe the claims, and again, it's the same approach that we discussed yesterday, where the invention, the claim itself, is broken down into its separate integers, and a comparison is then made. So in this instance, the comparison is made against the alleged infringement or infringing article or infringing process or method, and a comparison is made between those two. If they are all aligning up, so if A, B, and C is found in the claims, and A, B, and C is found in the alleged infringing article or method or process, then an infringement is found. Then the court also needs to ascertain whether the defendant has a valid defense to that infringement. So essentially, you are comparing the claims of the patent specification with the alleged infringing article or process. So quite a straightforward step. So very similar to the way in which novelty is assessed, where you're assessing the claims of the invention with the prior art documents. Okay, then the acts of infringement, we have touched on these, and I have included all those dictionary definitions there for you to have a look at to determine whether an act alleged to have been performed by an alleged infringer falls within one of the acts excluded in terms of section 45(1). Okay, if we then look to section 67, section 67(1) provides that a claim in respect of a patent for process or an apparatus for producing any product shall be construed as extending to the product when produced by the process or the apparatus claim. So if you are claiming a method of manufacture of a specific product, that method of manufacture, the protection that is provided for that manufacturing process extends to the product itself. So the patent will then also cover the product, even though it may not be expressly provided for in the claims. If the claims only seek protection for the method of manufacture or whatever process is at play, then the patent protection does extend to that product of that process. Then moving on to the next point, if the invention for which a patent is granted is a process for obtaining a new product, the same product produced by a person other than the proprietor of the patent or a licensee under that patent shall, unless the contrary is proved, be deemed in any proceedings to have been obtained by that process. So if another party is manufacturing the same product as you, it is assumed that that party is using the same process that is the subject of the patent. In considering whether any person has discharged the onus imposed upon him by subsection 2, the Commissioner shall not require him to disclose any secret process used by him in producing the product concerned, if it appears to the Commissioner that it would be unreasonable to do so. So if that party alleges that they are using a trade secret and the Commissioner feels that it would not be reasonable for them to disclose that, then the Commissioner may deem it not necessary. Then when it comes to contributory infringement, so where the patentee or when infringer is being aided by another party to commit the infringement, although not expressly provided for in the Patents Act, it was held in the Grand Paroi SA versus Sasol Limited case that contributory infringement does form part of South African law and it does relate to patents, even though it is not expressly provided for in the Patents Act. Contributory infringement is a form of delict. So in order to prove contributory infringement, you would need to prove that there was a delict that has been committed, and that is that there was an act or conduct, wrongfulness or unlawfulness, fault, harm, and causation. But you can have a look at that. Then what defenses does an alleged infringer have during the infringement proceedings? Well, obviously they can allege that they are not infringing the patent for whatever reason. They can then rely on the invalidity of the patent by counterclaiming for the revocation of the patent. They can also allege that they have an implied license under the patent from the plaintiff in the particular matter. And then also another defense would be that the rights of the patentee have been exhausted. So once an article covered by a patent has been sold anywhere by or without the consent of the patentee, the article may later be dealt with. And that we know is provided for in section 45, subsection 2. And you also see there that it is stated that the ignorance of the existence of a patent is not a defense. What remedies then does a patentee have to an infringement of the patent? There are a few that are provided for in the Act. They may be entitled to an interdict, so they can request the court for an interdict to stop the infringer from performing any of the acts that they are currently performing. They can also request the delivery up of any infringing product or any article or product of which the infringing product forms an inseparable part of. So it may not just be the products of that invention, but if it forms part of a greater product where it is inseparable from it, then that entire item may be delivered up. You can also seek damages. Also in lieu of damages, the plaintiff may also request that the court make a determination as to what a reasonable royalty would have been had there been a voluntary license agreed between those two parties, the two parties being the patentee and the infringer. So they can obtain, in lieu of damages, an award based on a reasonable royalty that would have otherwise been granted. Then also, not to forget, when submitting your prayers to the court for your remedies, because these proceedings are expensive, you are required to obtain expert witnesses. A lot of time is spent on educating the court on what the invention is, how the invention works, and so on and so forth. So all of these expert witnesses, the use of advocates is costly. So you must remember to also include your prayers for the costs of the suit, the costs of the counsel, and for expert witnesses. When it comes to infringement, section 68 is also important to note. And this is where there is partial validity or partial invalidity in a patent. That is where one of the claims of the patent are found to be valid and others not valid, then the court can stay those proceedings and permit the patentee an opportunity to remedy that invalidity. So if we have a look at the wording of section 68, it says, where in any proceedings for the infringement of a patent, the commissioner finds that any claim in the complete specification in respect of which infringement is alleged is valid, but that any other claim therein is invalid. So in the instance where the patent has one valid and one invalid claim, the following provisions apply. So where the defendant then has the counterclaim for the revocation of the patent, the commissioner may postpone the operation of any order issued in the infringement proceedings for such time as required to enable the patentee to make any amendment to the specification pursuant to the conditions imposed by the commissioner, who may attach such other conditioner to any order to be issued on the counterclaim as he may deem fit. So if there is an infringement, a defendant seeks to counterclaim for the invalidity of the patent, and it is found that one of the claims is valid, but the rest of the claims are invalid, then the commissioner can stay the proceedings and permit the patentee the opportunity to make the amendment before the court. So this is where section 5110 of the Patents Act comes into play, where an amendment is sought before the court for the patent. And that is then to remedy any defects in that patent to ensure that the patent is in a valid form and that the patentee still has an enforceable right against the alleged infringer. Then subsection 2B, when the specification has been amended in terms of paragraph A, so this is where during the state proceedings, the patentee has amended the specification to bring it into a valid form. The commissioner can order costs to the defendants in the infringement proceedings, and he may also grant relief in respect of any claim which had before the amendment been found to be valid and infringed. And in exercising his discretion, he may take into consideration the conduct of the patentee by inserting the specification those claims which had been found before the amendment. So if the court finds that the patentee was aware that their patent was partially invalid by virtue of prior art that came to the knowledge of the patentee, and they didn't remedy that patent before they instituted proceedings, or there was a delay in remedying that invalidity, then the court will not look favorably upon the patentee. So they will take into consideration the conduct of that patentee when it comes to a costs award or damages. Does anyone have questions regarding infringement? Okay, then declarations as to non-infringement, please mark this slide for self-study. It is set out verbatim, and I'm not going to rehash that. It is quite clearly set out in the Act. Then there are provisions in the Act where an infringement is excused, and that is known as your BOLA provision, and that is section 69, capital letter A, where a certain act is not considered to be an infringing act. And section 69A1 states that it shall not be an act of infringement of a patent to make, use, exercise, offer to dispose of, or import the patented invention on a non-commercial scale and solely for the purpose reasonably related to the obtaining, development, and submission of information required under any law that regulates the manufacture, production, distribution, use, or sale of any product. And this provision is probably most relevant to generic pharmaceutical manufacturers, where a patent does exist for the pharmaceutical, but it is probably nearing the end of its life, and then the generic manufacturer, pharmaceutical manufacturer, after the expiry of the patent, is permitted to manufacture that pharmaceutical. But obviously, before entering the market, certain additional requirements need to be complied with in terms of other statutory requirements. So market approval for that medication, there would also need to be trials done on this generic product before it is deemed safe for human consumption or animal consumption. So before the expiry of the patent, a generic pharmaceutical company is able to make or use or exercise the patented invention in order to obtain whatever additional regulatory approval is required before entering into the market. Okay, and this is what is known as the BOLAR provision. Then section 69A subsection 2 does state that it shall not be permitted to possess the patented invention made, used, imported, or acquired in terms of subsection 1 for any purpose other than for obtaining, development, or submission of information as contemplated in that subsection. So they cannot purchase a whole load of the pharmaceutical for themselves and then basically resell it. It is only for the purposes of obtaining whatever approval is required to allow that product onto the market once the patent has expired. Then having a look at section 71. Section 71 provides a party to a remedy where there are groundless threats of infringement proceedings. So as a patent attorney representing your client, you need to be very careful not to unjustly threaten another party with infringement proceedings, because if that is the case where these threats are groundless, then that party does have recourse to the commissioner. And that is then either a declaration to the effect that such threats are unjustifiable. That party can also obtain an interdict against such threats, and you may also recover damages for any that person would have incurred. So if we have a look at section 71, it states that where any person by circular, advertisement, or otherwise threatens any other person with proceedings for infringement of a patent, a person aggrieved thereby may, whether the person making the threats is or is not entitled to or interested in a patent or an application for a patent, institute proceedings against him and obtain a declaration to the effect that such threats are unjustifiable, an interdict against the continuation of such threats, and they may recover such damages, if any, as he has sustained thereby, unless the person making the threats proves that the acts in respect of which the proceedings are threatened constitute, or if done, would constitute an infringement of a patent in respect of a claim in the specification, which is not shown by the plaintiff to be invalid. So you cannot willy-nilly, as the patentee, unjustly threaten other parties. You must be able to substantiate that there is a valid infringement in order to overcome the commissioner making any of these findings, such as an interdict or awarding damages to the aggrieved party. Are there any questions? Okay, then I said that evidence is self-study, so you can have a look at section 72 to 74. Then the last chapter, or second last chapter, appeals to the Commissioner and the court. You can also have a look at the provisions relating to these for self-study, so section 75, 76, 77, and then also criminal offences and penalties, where you cannot falsely represent that you are an official of the Patent Office, falsely claiming to be a patent attorney. Things like that are criminal offences which are provided for in the Patents Act as well. So please do have a look through section 81 through to section 85. Are there any questions then? That brings us to the end of the workshop. But before we go, are there any questions that you need me to address or require clarification on any of the topics that we've discussed these last 2 days? Hi, Isaac.
Yes, hi, Marco. My question is based on the contract of employment. Yeah, we have what is it, the case? The King versus SA Weather, of which concerns wherein the inventor invented an invention in the scope of his employment. And then we have a case of which is not yet decided, the one of McCarthy versus Vodacom, on which McCarthy invented an invention wherein the invention was outside the scope of his employment. So I just want to find out as to how are the development of that case, because it has been stayed for a while, and there's no judge went to the Supreme Court of Appeal, but then the Supreme Court of Appeal decided on McCarthy's favor, and then Vodacom challenged it in the Constitutional Court. So, what are the developments with regard to that case, as far as the invasion of the scope of it is concerned?
Look, so the SA Weather Services versus King case, or vice versa, King versus Weather Services, that wasn't related to an invention. That was a copyright case. And in that case, the Mr. King, I don't know his first name, so I'll refer to him as Mr. King, had devised a program. Although it wasn't in the course and scope of his employment, that program did assist him in executing his duties in his employment. And for that reason, the courts found that it was considered the Weather Services copyright. And also, when it comes to the Please Call Me case, look, I haven't been following the developments recently because there hasn't really been much going on. So I can't say where they are with the proceedings, except that it is, as you said, before the Constitutional Court. But I guess in that case as well, I mean, I'm not entirely sure what McCarthy was employed to do, but if it was to innovate or to create programs, then I would think that that Vodacom would be entitled to some or to the invention that he had created. But unfortunately, I can't really comment much on that case. Sorry, Isaac.
No, it's fine. Yeah, but then just to add on, McCarthy was in accounting department.
Okay.
Yeah, but then it's okay. It's fine, Marco.
Okay. Are there any additional questions? Okay, so Ashley asked the question, for the BOLOP provision, how long before the expiry of the patent can the generic manufacturer begin those acts? So there isn't any express timeline provided for that. So I assume it would just be a reasonable time. in order to obtain market approval for generic drugs, it does take a lengthy period of time. So I think so long as they are obtaining the patented products and they are not selling it or stockpiling it, and it is solely for the purposes of obtaining the regulatory approval to enter the market, then they are fine to do so. I don't think it matters how long beforehand. Okay. Okay, I think that then brings us to the end of the workshop. Thank you everyone for your attendance. As I mentioned yesterday, I will set up a Q&A session once I've returned from my business trip, and we can then work through the last 2 years' exam papers. Please do begin your preparations for the exam before that date so that we can work through the questions that you may have, and then also to work through those exam papers. As I said, I'm going to be coming unprepared to that. It's not a lecture, it's not a presentation. It's merely to address any questions that you have and also to get your input on the exam papers. Isaac, I see you have another question.
Yes, yeah, it's not a question, just a friendly reminder to send us the slide which after
Yes.
the presentation, after the University of Pretoria case versus the registrar.
Thanks. I have made a note of that. That's the Mu Mechanicos case. Thanks, Isaac. I will send that through to everyone. I have got quite a bit of work to catch up on today and for the rest of the week, but I will try to put the recording of the workshop onto YouTube by the end of the week, or at least the end of next week. So please do just allow me a bit of time to get through to everything. And then I wish you all the best in preparations for your exams, not only for this module, but for any other exams that you have upcoming. And take care of yourselves. As I said, I am always available should you have any questions. So please do feel free to reach out to me via email or to set up a call. Okay, thank you everyone. All the best for the afternoon. Take care.
Thank you, Marco.
Pleasure. Thanks.